Every day in the USA, people find themselves in court.
Given the circumstances, at least as I understand them, and because I haven't heard the entirety of the case or anything,
Right, exactly.
I'm
Probable
going,
cause or anything.
I'm going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. Set a bond violation hearing, April 16th, 2024 at 2 p.m. At 2 p.m. Is there anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tender division.
I don't know what you're asking me.
If the tether situation can be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. Thank you. Court does call the case of the People's State of Michigan versus Cody Jolly.
On behalf of the people.
I think it doesn't matter. State your name, sir. All right. Date and time set for a preliminary examination. Are people ready to proceed?
That is correct, Your Honor. People are ready to proceed. A few things at the outset. I would ask defendant be reminded of his absolute right to an attorney for
Yes,
this.
I will get there.
Okay, and I also asked Ms. Gaines to be present if Your Honor would be willing to appoint standby counsel if the defendant does not want to be assigned an attorney. I also am going to make an offer to Mr. Jolly to plead to an added count 3 and 4 of aggravated assault under MCL 750.81A. That is a 1 year and or $1,000 misdemeanor offense. In exchange, I would dismiss counts 1 and 2, which are criminal sexual conduct in the 4th degree, which are 2-year misdemeanors and are $500. And would require registration on the sex offender registry. This is the first opportunity I've had to speak with Mr. Jolly, so I would ask that he decide if he wants to move forward with the exam or if he wants to take that offer.
What's the offer?
The offer is to plead to an added count 3 and 4 of aggravated assault, which is a 1-year misdemeanor and or $1,000 fine.
But what's the suggestion? I mean, that's not a plea. I understand that you're changing the charges, but there's no plea. What's the plea?
That is the plea offer, and then I would dismiss count 1 and 2, which you're currently charged with, which is criminal sexual conduct in the 4th degree. That is the plea offer, sir.
So what's the jail time? A year in jail is what you're offering?
The maximum penalty for that is a year in jail.
There is no plea. So you just want me to
Hold it, Mr. Jolly, Mr. Jolly. No, you're trying to argue. Mr. Jolly. They've offered you, that's an offer. Okay. But hold on, before you just start making these rash decisions. because that's how you're where you are right now. Okay? So first thing I want to advise you is today's the time set for your preliminary examination, and you've elected to represent yourself. I will tell you that having watched you through the various proceedings, I have some concerns about you representing yourself. And but you're absolutely have a right to do so. But I need you to understand that you're charged with 2 felony offenses or high court misdemeanor offenses of criminal sexual conduct in the 4th degree. You understand that, sir? You understand that they're punishable by up to 2 years incarceration, $500 fine plus court costs, mandatory HIV STD testing, and DNA would be, well, DNA was taken upon your arrest. Do you understand that, sir? All right. Now, you understand that there are grave dangers that can occur by you proceeding on your own without counsel. All right. You understand also that I'm not here to play favorites to either side. And so I will not be in a position where I can assist you in any way. I will hold you to the exact same standards regarding court rule, presentation of evidence, and everything along those lines that I would hold the people to. You understand that? You understand that if you wish at any point to be represented by counsel to help assist you in any way, that the court would make sure that counsel would be provided to you.
I do understand.
All right. Now, Mr. Jolly, and I'm going to say this, not necessarily part of the admonitions, I'm very concerned that you don't know what the proceeding that you're in right now is.
The preliminary examination, when you told me initially, you told me that when preliminary examination happened, you told me that the two alleged victims would be here on today's.
I didn't say that.
Okay, so they don't have to be here today?
I did not say that.
Are they supposed to be here?
Do you know what proceeding you're in? Okay, let me ask you this. If the people are successful at a preliminary examination, what do you believe happens?
To ask for a request to move on preliminary, and I'm also asking for a jury trial today.
Okay, but
Then I would.
Mr. Jolly. If the people meet the burden, what do you think happens?
Pardon, what?
If they meet their burden at a preliminary examination, what do you think happens at that point?
We'd have to go on to either preliminary or trial, depending on what your decision.
You understand that you're at the preliminary now.
He said it was examination, but if this is preliminary, we can move on to trial. I'm okay with that. I expected there to be 2 witnesses here today, two alleged victims here today. That's what I expected. I think that's right according to the way it should have been. I thought that was right. I am asking where the 2 witnesses are, two alleged victims. Yeah.
Mr. Jolly, I understand you want to get to a certain point. I have concerns about whether you understand what you're doing.
Yes, I do.
What do you believe you're doing?
Trying to get to trial. Proven innocent.
You understand you don't have to prove your innocence.
I understand that you would have to prove, so the courts, whoever the state would have to prove me being guilty beyond a reasonable doubt. And
Mr. Jolly, have you?
We have where are the 2 alleged victims that were supposed to be here today? Question.
Sir, I'm not sure how the people are going to proceed in their case. Okay? So I'm not going to answer your question because I don't have the answer to that. Do you understand the offer that the people have made to you?
I do,
Pardon?
I do understand the offer.
What do you understand the offer is being? What do, what,
Two other choices, I understand.
Mr. Jolly, do not overtalk me, because it will never work. Are we clear? Mr. Jolly, are we clear? Are we clear? Do you understand the offer that the people have made?
I understand.
What do you understand that offer to be?
They said they're dropping from the two, from the CSC they're requiring, but they're dropping them to assault. So there's still two charges and up to a year.
But two misdemeanors
Correct. This is,
that may not have any incarceration with it.
problem is I didn't do anything. So that's really hard to plead anything. So,
Let me ask you this, Mr. Jolly. They don't have to represent you. All right. But would you at least like to talk to an attorney about what that offer means? And what risks that you're potentially taking in just outright saying no, as opposed to whatever? Would you at least like to talk to an attorney about that?
I'm just gonna move on. To be honest, I'm just gonna move on.
You're not answering my question. Would you at least like to talk to an attorney? I'm not trying to have you bind to anything, but just to have somebody explain to you what it means. Would you at least like to talk to somebody? I'm not even saying.
Honestly, okay. I'm just upset.
What?
I'm upset with the entire court process.
Okay, you can be upset with the entire court process. I just want to make sure you understand everything that you're doing and to provide you an opportunity to talk with legal counsel to explain this and that. That doesn't take it out of being your decision.
Right.
But at least you can talk to somebody and get more information in making that decision.
And I have no need for it. If you're required, I'll talk.
I'm not requiring you, Mr. Jolly, quit playing the victim. I'm not requiring you to do anything. I'm offering you an opportunity to talk with a lawyer so that at least everything can be explained to you before you make a decision. Because my concern is that you're making a rash decision heading forward, not quite understanding entirely what you're doing. You're trying to get someplace, and I don't think you know where you really want to get to.
Thank you. Trial. I thought there was a preliminary to this. There's not.
There's a preliminary today. You understand that?
I would ask for a jury trial.
Okay, that's it. I'm done. I explained to you at the last proceeding when a jury is going to happen and when these proceedings are going to happen. Because at this point, do not overtalk me again. I'm done trying to deal with you. I thought that there was at least some rationality to your thought process and what you're trying to do. I am very concerned about that. I'm very concerned about your competency to be able to stand trial and to head forward. Because you're not tracking what I'm telling you. You don't have to agree with me, but you're not even tracking what I'm telling you. You're off on something else. I thought the last time we were here that was some sort of aberration and not something that is fit you. And I explained to you that we were going to this proceeding, and I don't think you know what proceeding you're in. And you keep saying at times the same thing to me, although I explained to you process-wise how this happens. And so what I'm going to do on my own motion, for good or for bad, but I have to make sure and be sure that this is going to happen. And in light of the activities also of the bond violations, I'm going to refer to dependency on my own motion for competency in this case.
Can I just go talk with the attorney?
And Ms. Willingring, if you would be so kind for the court to prepare an order to that respect. I'll set a competency hearing for, give me 60 if we can get it done. We'll have to adjourn it out.
June 27th at 9 a.m.
June 27th, 2024, 9 a.m. is when I'll set his competency hearing, and I'll look forward to the order.
Question.
Now, do you want, you indicated you want to talk with an attorney.
If you would like me to talk to an attorney instead, that's okay, yeah.
No, it's not instead. If you want to talk with an attorney, Mr. Jolly, I will make sure that that happens. Do you want to talk to an attorney?
Put me through competency then.
No, I'm not putting you through anything.
You said June
Do you
27th.
want to talk to an attorney? Yes or no?
Yeah, sure, I'll talk with him, but I don't want to.
Fine. Ms. Gaines, he does not wish to have appointment. Would you assist the court in speaking with Mr. Jolly? I've set it for competency, but maybe he has asked for some legal advice. Can you assist the court in that way, Ms. Gaines?
Yes, sir.
Thank you. So we'll do that. I'll have his bond continue. You can take the defendant back, and Ms. Gaines will be back there to talk to you momentarily, sir.
One more question, just the jury trials, that's still.
That's the problem. You don't even understand where you are in the, no, you don't. No, you don't. I'm done. Bye.